Anthony D'Angelo, the founder of D'Angelo Law PLC. I specialize in business immigration, and I've been in this field for about 5 years now. I focus my practice on obtaining permanent residence for my clients through employment-based petitions, specifically extraordinary ability petitions and national interest waivers. I am also very familiar with family-based petitions and naturalizations and other non-immigrant visa applications such as H-1B, L-1s, and O-1s. I've been wanting to make this video for a while now. I just haven't had a chance to get around to it, but I've been receiving a lot of questions from my clients regarding applying and obtaining certain governmental benefits due to the coronavirus pandemic. And I think it's very important to talk about it because there might be some confusion about it, and people don't understand the type of implications that it may have on your application for permanent residence or an application to extend your status or change your status within the United States. So I'm going to get into a little bit of the background, but it's primarily going to focus on the whole public charge rule and the implications on applications for permanent residence. So USCIS is United States Citizenship and Immigration Services. They are the part of the Department of Homeland Security that's responsible for adjudicating the petitions for permanent residence and non-immigrant visa applications filed within the United States and those sorts of things. So as most of you know, on February 24th, USCIS's Public Charge Rule went into effect. And that rule applies to green card applicants through adjustment of status, as well as those applying for extensions or changes of status within the United States. So basically, the final rule defines public charge as an alien who receives one or more public benefits for a period of 12 months within a 36-month period. Also, under the final rule, it allows USCIS to determine whether an applicant would be likely to become a public charge. So it means more likely than not, they would become a public charge in the future. They would depend on public benefits in the future. It gives USCIS a lot of discretion and allows them to focus on certain factors in order to make that determination, whether they would be considered inadmissible. And I'm going to read from my notes here just so I don't accidentally summarize anything incorrectly. I want this to be as accurate and informative as possible. So, under that public charge rule, the adjudicating officer will weigh certain factors under the totality of the circumstances test. Now, anyone that went to law school knows about the totality of circumstances, basically like anything goes. So, they'll consider age, health, family status, assets, resources, and financial status, education and skills, prospective immigration status, expected period of admission, and sufficient affidavit of support. I want to talk about the public charge rule in general because it's very applicable to everyone applying for some sort of status or permanent residency within the United States. So I'm going to discuss a little bit about the public charge rule and its part in the application process, what forms that we have to submit, so on and so forth, and then I'll talk about coronavirus and how it applies. So I discussed about age, health. You submit the medical exam, so if you have any of those, any illnesses, which would make you more likely to depend on governmental benefits, that's taken into account. Assets, resources, and financial status. So, as part of the adjustment of status application process specifically, in addition to submitting your typical forms, you also have to submit the I-944 form, which is Declaration of Self-sufficiency. Now, the whole reason behind the public charge rule is that USCIS wants self-sufficiency. They want to approve applications for those individuals who will be self-sufficient and can support themselves and their families and will not depend on governmental benefits. So the I-944 form comes into play, and it's for everyone. Before, if you were filing a family-based petition, you would need a sponsor, and you would need that sponsor to sign an affidavit of support showing that they had sufficient resources and income to take care of you, and so on and so forth. Those that were filing employment-based petitions, whether they were being sponsored by their employer or self-petitioning, were not required to submit an affidavit of support, and were not required to show that they had sufficient financial resources. Now, the I-944 form must be submitted for everyone. Obviously, there are some few exceptions, but typically it's for everyone, including your children. So anyone applying for adjustment of status application must complete and sign this declaration of self-sufficiency and submit it with their adjustment of status application. As part of that form, you have to disclose your income proof through tax return. You have to disclose assets, any liability, debts and liabilities that you may have. You have to submit your credit score, credit report. You also have to submit proof of health insurance. You have to disclose if you've ever obtained any public benefits, and there's an enumerated list. If you've ever filed for bankruptcy, whether in this country or abroad. And if you don't have an immigrant petition for alien worker approved, you have to show whether you've graduated from high school, if you have any undergraduate or graduate degrees or diplomas, if you have any occupational skills or certifications. All of that is included in this brand new form, which is very extensive, and you can see how USCIS uses this form to check off all of these factors in determining whether someone would likely be a public charge. So some applicants have to submit the affidavit of support as well, in addition to the I-944 form, family-based petitions. But those employment-based petitions still do not have to file the affidavit of support. They don't need a sponsor, but they still need to prove their self-sufficiency. So there are certain benefits, public benefits, that are not considered under the public charge rules. So your receipt of these certain benefits would not make you a public charge, and therefore inadmissible. So the Department of Homeland Security and USCIS won't consider emergency medical assistance, disaster relief, national school lunch programs, the special supplemental nutrition program for women, infants, and children, the children's health insurance program, subsidies for foster care and adoption, government subsidized student and mortgage loans, energy assistance, food pantries and homeless shelters, and Head Start. Those are the benefits that they have enumerated in their public charge policy, their public charge rules that would not be considered. Now notice how it doesn't say unemployment. On USCIS's website, they published an additional list of the public benefits not considered in the public charge inadmissibility determination, because they are considered earned benefits. Federal Old Age Survivors and Disability Insurance Social Security Benefits, SSDI. Social Security. Veterans benefits. Government, including federal and state pension benefits and health care. Unemployment benefits, workers' compensation, Medicare, or federal and state disability insurance. So those benefits are published on USCIS's websites as not considered in the public charge inadmissibility determination, because they are considered earned benefits. Unemployment benefits. So there's your answer. So if you are applying for adjustment of status, change of status or extension of status, and you have applied for unemployment benefits, it will not be counted against you because it is considered a earned benefit. Now, I want to caution you, because as with many things with USCIS, there's always a little gray area. In response to coronavirus, USCIS published on their website a sort of explanation regarding the public charge determination and how obtaining certain benefits because of coronavirus can have an effect on your application. So I'm going to read that, and then I'm going to talk about it a little bit. So they state, if an alien subject to the public charge ground of inadmissibility lives and works in in a jurisdiction where disease prevention methods such as social distancing or quarantine are in place, or where the alien's employer, school, or university voluntarily shuts down operations to prevent the spread of COVID-19, the alien may submit a statement with his or her application for adjustment of status to explain how such methods or policies have affected the alien as relevant to the factors USCIS must consider in a public charge inadmissibility determination. For example, if the alien is prevented from working or attending school and must rely on public benefits for the duration of COVID-19 outbreak and recovery phase, the alien can provide an explanation and relevant supporting documentation. To the extent relevant and credible, USCIS will take all such evidence into consideration in the totality of the alien's circumstances. What does this all mean? At all times, USCIS retains the right to use their discretion in making the public charge and admissibility determination based on the factors I've talked about, the type of benefits obtained. Now, on one hand, there's certain earned benefits that they won't consider, for example, unemployment. But on the other hand, they're saying that if the COVID-19 outbreak and recovery phase and social distancing and quarantine has prohibited you from being able to work or attend school, things that are tied to your status or things that are tied to your ability to support yourself and not rely on public benefits, then you must submit a statement with your application explaining it, and then they'll take it into consideration. Essentially, if you are applying for any extension of status, change of status, permanent residency, or you will apply for it in the future, be very cautious with your options for COVID-19 and obtaining certain public benefits. The moral of the story is, before you do anything, definitely contact your immigration attorney and ask them if it would have any impact on your application, be it now or in the future, just to make sure, because it's so much more difficult to deal with it on the back end when it's already happened and now you're scrambling for a way to try and explain it and figure things out and your back's up against the wall. Then to do it on the front end and make sure all your bases are covered, you know what you're allowed to apply for, what you're not allowed to apply for, so there's no confusion. You don't want to be faced with a situation where you're about to apply for permanent residency and you're absolutely considered inadmissible and you will never be allowed to adjust status within the United States and get that green card because of your reliance on a certain public benefit in the past. So definitely give your immigration attorney a call and definitely get all of that cleared away. I hope this video was helpful and informative. If you do have any questions, please feel free to contact me. I do plan on making more videos in the future, getting into other topics, more relevant topics. I just felt like this video had to be done. I do think that this topic was very, very important to talk about. It's very relevant with today's climate and with COVID-19, and a lot of people are facing those issues in which, okay, now I've been laid off or I've been furloughed and I don't know how I'm supposed to make money or feed my family. Can I ask the government for help? Everyone's, able to apply for it, things like that. So that's it for this topic. I hope everyone has a happy Easter and thank you for watching.